Good afternoon, ladies and gentlemen. Welcome. Thank you for attending our mediation information session this afternoon, presented to you by the Mediation Institute of South Africa. My name is Jan de Tooy, and I will be your host for this presentation or for this session. And without further ado, let me introduce you to the speakers for today. Right, so the first speaker will be, in no specific order, Viraj Shrikasan, the Director of Fair Practice and ADR trainer, as well as an international civil and commercial mediator, as well as Andre Klaasen, Managing Director of SA Labour Guide, and also the Mediation Institute of South Africa, also ODR International Civil and Commercial Mediator. And from all the way from Cape Town today, Mr. Gunther Williams, also from the Mediation Institute of South Africa, but also practicing attorney, Patton Williams Attorneys in Cape Town, and also an ODR International Civil and Commercial Mediator. I was also informed that there will be a fourth speaker today, Mr. Renee Bosov. Unfortunately, I don't have his name on the screen, but Renee will also have an opportunity to address you today. Right, ladies and gentlemen, I see, and if I'm looking to this side, I work off two screens. I see that there are still people logging on to the session. Until such time, let's quickly have a look at the program for the day. The duration will be 1 hour, and what will be shared today, first of all, what exactly is mediation? How will it assist you? How can it assist you as an individual or as a business? And the differences between mediation and litigation. And I think at the end of the presentation, you will understand that there are so much more benefits involved in mediation compared to litigation, and the advantages thereof, one of them being cost saving, of course. Right, ladies and gentlemen, so that is what will be presented today. Before I hand over to the speakers, just some formalities in terms of housekeeping. If you experience difficulty hearing or seeing us, please reconnect. So we found in the past that where individuals experience problems, the best is to just disconnect your internet connection and reconnect and rejoin the discussion. The Q&A function. So you should on your screen now see two options, two buttons on the at the bottom of the screen, a Q&A button and a raise your hand. Now, if you raise your hand, you can all just click on it because I know you are dying to click that button. So quickly click it for me, please. I can see, there we go. Thank you. Now you've all raised your hands, and now you can again lower your hands as well. Right, so up front, I'm going to tell you that we will not today take questions live. So normally when you raise your hand, it will indicate that you want to be assisted, and we would then have unmuted your microphone. However, today, due to the number of participants, it will not be possible. So we have a couple of hundred people attending today. So we will only work off the Q&A function. Now, the second button, the Q&A button, if you click on that, you will see that there's an option for you to type out a question. You are very welcome to type questions for the presenters to consider and to respond to. Of course, time will not allow that we answer all the questions, but the most relevant ones we will, of course, address. And then during the presentation, we may also ask you to participate in a poll. It is anonymous, so you are welcome to participate. It will be shared on the screen, and as I said, anonymous. So don't be afraid that your information will be leaked. Right, so that is it from my side. I see a couple of Q&As already started to come in, and I'm sure that the speakers are eager to get going. And I'm just going to ask Andre, Viraj, and Gunther to just unmute your microphones for me, please. There we go. Thank you very much. I'm handing over to Andre. Andre?
Okay, thank you very much, Jan. And thank you, everybody, for the opportunity and for taking time out of your busy schedules to attend this mediation session with us. We really appreciate that. First of all, I want to emphasize the fact that I'm really passionate about mediation. I'm passionate about mediation because mediation is a win-win situation. There are no losers in mediation. Often we think about a win-win situation where two parties are in a dispute. Normally there's a continued relationship between them, whether you are corporate, whether you are working with your suppliers or whatever. But we think about a win-win situation where one person or one party have to give something away, or both parties have to give something away in order to reach an agreement. And that's not a real win-win situation. A win-win situation, and we want to change this whole idea of a win-win situation. A win-win situation is where both parties win. In the book Getting to Yes by authors William Ury and Roger Fisher make an example where two kids are fighting about an orange. The one, ultimately they decide that they are going to divide the orange. The one kid took the orange, ate the inside and threw away the peel. The other kid went into the kitchen, threw away the inside and used the peel to bake a cake. So what if we can invent options for mutual gain where there are seriously no losers, but only winners? What if we can separate the people from the problem? And what if we can say, listen, the other side or the other party is not the real problem. This is our problem. And often if we deal with conflict, I know about all the conflict styles. You've got hard approach, you've got soft approach. But what if we can combine the hard and the soft and the avoidance style? Be hard on the issue at hand, but be soft on the people, and that we really separate the people from the problem and understand that the other person in front of us are not really the problem, but the problem at hand is actually the problem. So let us invent options of mutual gain. And the Harvard Institute called this expanding the pie. Sometimes the solutions are right in front of us. But as parties, we only see our own problems, we only see our own advantages, and we hardly see the advantages of the other side. So the whole idea of this is to get a win-win situation, to give new meaning to the whole win-win situation, to expand the pie, and where both parties can actually be winners in this situation. Then about the Mediation Institute. As I said, I'm very passionate about mediation. I really like the win-win situation. I've handpicked a few individuals. In total, we are 14 currently on the panel. All 14 on this panel are internationally accredited. This means that they can also deal with international disputes, both civil and commercial. It also includes family mediation. We've decided as a Mediation Institute that we are not going to affiliate with any other organization in South Africa. As you know, mediation is not regulated in South Africa. So we decided that as a Mediation Institute of South Africa, we want to raise the bar. And by raising the bar, we mean adhering to international standards. So from a Mediation Institute, there are attorneys, there are advocates, there are business leaders. So if you have any other questions on that, you're more than welcome to email me. Jan, thank you so much for your time. I'm not going to take up too much more time for this. Thank you so much. Viraj, can I maybe hand over to you now?
Sure. Thank you, Andre. So I'm part of the mediation group that Andre has put together. And today we've brought together this webinar to introduce the principles of mediation, introduce what mediation is, and to maybe answer, if we have time, some of your questions on what you think mediation is, or where you need more information on this. Before I go into what mediation is, Gunther, is there anything you'd like to contribute here?
Thank you, Viraj. Good afternoon, everybody, from a sunny and lovely Cape Town. Glad you could join us today. At this point, no, Viraj, I think I'll hand over to you. I'll just jump in later because I've got a very specific topic, especially with mediation in the workplace scenario. So I'll jump in later.
Thank you. All right. So everyone, thank you for making time to spend with us in the middle of your afternoon. And we're going to try and give you as much information as we can. And if you can't watch the space, we'll have another session and give you everything that you missed out on this time round. So I want to first start off with what is mediation? Because generally the perception is that mediation is therapy, it's a second-rate dispute resolution process, which it isn't. In mediation, you do not get counseled. And it's not because you choose to mediate, you cannot afford legal services, or you're the weaker party. That's not what you're going to find in mediation. Mediation is a dispute resolution process, and it facilitates negotiations, which is facilitated by an impartial third party, which is the mediator. The participants in mediation speak for themselves and they are heard. So they listen to each other. And even if they have legal representation, the legal representation can be present, or they can consult their legal representation outside of the mediation process. So it doesn't prohibit access to legal representation. Now, when the parties are engaging with each other directly, they can speak to each other in terms of their issues, their concerns, their fears, their needs, and then have these addressed with each other in the same room or with a mediator, which will eventually lead to the negotiations being more constructive and a resolution being reached by the parties that is realistic and is something that they can fulfill on. Now, one thing you've got to understand about a mediator does not make a finding, the mediator does not provide an outcome, and the mediator does not make decisions for the party. You have to understand that. The mediator is impartial, and the mediator does not make a judgment, and the mediator does not make an order. So I want you to keep that right there in your mind, who the mediator is. And we will discuss later, if you do not reach resolution in mediation, what are the options there and what are the outcomes there. Now, when you are in mediation, you will experience the principles of mediation. And I'm going to briefly explain it to you because your mediator, when you do have one, will go into more detail about these principles. But I want you to understand that when you go into mediations, these principles must be prevalent. So the first one you've got to understand is that mediation is done without prejudice. So any offer or tender or proposal that you make in mediation, it will not be disclosed and it will not be held against you in a court proceeding or proceedings outside of mediation. So what you're saying is nothing is cast in stone, it is written in sand, and until you both are comfortable reaching that final decision. You, as the parties, you enter in good faith. So you will be given a mediation, an agreement to mediate, and it will outline the rules of engagement. You'll understand, the mediator will explain to you what is expected in terms of acting in good faith. And you will work in good faith during mediation to reach a resolution, which is constructive. Now, acting in good faith means do not use mediation to abuse the process, to intimidate someone, or just to come in there and ask for information that the person has no idea why you need it, the relevance of it. So the mediator will manage that use of the process. Mediation is also voluntary. So you cannot be forced into mediation if you do not agree to attend mediation unless it's mandated by the court. So there's two levels of voluntariness to the mediation. The first one, you can both attend by agreement and decide we're going to agree to mediate, or the court mandates the both of you to attend, and staying inside that mediation now becomes voluntary. So you volunteer to reach agreement within mediation. The next principle of mediation that you must be aware of is confidentiality. And confidentiality is key in this mediation process. And I'm sure all the panelists will talk to you about this at some point. And confidentiality is something we can talk about in a whole other session for an hour, but I'm just going to give you the basics about it. There are two levels, again, for confidentiality. The first one will be that the process is confidential. And the second one is that anything you say to the mediator remains confidential unless you give permission to the mediator to share this information. Because we want mediation to be a safe space for the parties, or the participants to the mediation. You need to use confidentiality in this process to create that safe space as a mediator, and those of you who are in the mediation, because in mediation, as Andre has spoken about, you start inventing options. And when you're inventing options, you don't want to feel fearful that if I put an option on the table, it's going to be held against me. You also want to explore these options, and your mediator will give you that opportunity, because remember, they're facilitating your negotiation. So they're going to go into that negotiation process as well with you. Now, when you're inventing those options and looking for that mutual gain, you also don't want to feel that all of this communication is going to be used against me in a court proceeding. So the mediator has to constantly remind you and remind the other participant that these proceedings are confidential. Now, there is the issue of who my mediator should be. And that is another principle that we look at in terms of who is appointed as the mediator. And the mediator must be impartial and neutral. Now, there are all questions we've received asking, can my lawyer be the mediator? Can someone I know be the mediator? I trust them. It's not about whether you trust them. It's about whether both parties will believe and perceive that mediator to be impartial and neutral. To be neutral, the mediator must not have any interest in the outcome. So you technically cannot use a legal representative, the one party, to be the mediator, because the outcome is then biased in the favor of the person that mediator represents. So there's a lot of technicality about who you choose to be your mediator. Go with someone you both agree to being the most impartial and neutral person for this process. Now, you're sitting in this mediation and you're the participant. How do I know my mediator is effective? Well, the mediator firstly does not make a decision that I've explained to you earlier. The mediator does not give any advice, they only give information. So your mediator has to be competent in the area of the dispute. The signs of a good mediator is that they let you know if anything has transpired that might affect their bias or their impartiality. Okay? So they're not afraid to show their commitment to that impartiality. A skilled mediator, it doesn't matter about experience, because we know that most mediators are not gaining as much experience as we'd like them to because of the misunderstandings of what mediation is. But look at the skill of that mediator. The mediator must be able to move easily between the different styles of mediation. And if they're competently trained, they will understand what those different styles of mediation are. So they can facilitate an evaluative approach to weighing up options. Now you're sitting in that mediation and you need to evaluate your options to understand which one is the best for my particular outcome, okay? If there's a relationship that they need to protect in that mediation, that mediator needs to facilitate a transformation of that relationship from being an adversarial one to an amicable one. So the mediator will be familiar with negotiation processes, and they will be able to facilitate through these processes. Now, sometimes you would think, and I get this a lot, where Someone will think, well, what if I contacted the mediator first and I told him my story? And then the other person thinks, well, that person contacted the mediator first. The mediator has heard their story. The mediator believes their story. So why should I even engage in this process? I'm sure the mediator is biased. A competent mediator will not affect those conversations that will not let that allow them to affect their impartiality. And when you're in that mediation, you'd be able to tell if the mediator has been affected by any biases or prejudices that they might have. Again, I need to emphasize this. The mediator does not give advice. They do not make a decision. They only give information. They do not let their own biases and prejudices affect the process. And a good mediator will always allow the participants to be heard, and they will manage any power imbalance in that mediating room. Now you've come into this mediation process, and you're wondering, what am I supposed to experience? I've never been here. I'm also a bit wary because I might have a view that it's therapy and I'm going to be counseled, and I don't want that. Well, it is a structured process. So the mediator that you've decided on will send you both an agreement to mediate, or you'll receive an agreement to mediate. And the agreement to mediate will set out the terms of this mediation. So you will have an understanding of what is expected of you. You will each also get to speak to the mediator. So prior to your first session, the mediator will introduce themselves to you, and they'll have a very brief understanding. So the mediator will not sit and listen to your full story. They're not going to listen to your full dispute, because that is something they want to listen to in mediation, and you will get that opportunity. So remember, in mediation, you have that opportunity to speak, and the mediator is going to allow you that opportunity to speak. If you engage with the mediation, in the mediation, and you can see that it's one-sided, then by all means, you now know that it has to be an impartial process. The mediator has to be impartial about it. Once you receive your agreement to mediate, you can then proceed into the process. You will have to send your signed document to the mediator. You will be reminded if you're in a commercial dispute, if you have agency, to be there. And the mediator then guides the participants. So you will not be lost. That's what the mediator is there to do. They're there to facilitate the process. You won't be lost in the process. Now, the other thing about the process is that the mediator will use different types of sessions. They will use joint sessions, or they will use individual sessions, which we call caucus sessions. It is the prerogative of the mediator to decide when they're going to use joint or caucus sessions. It doesn't mean that when they call a caucus session for one person, they're not going to call for the other person. Both of you will have the opportunity to meet the mediator in individual sessions. That's a balanced process. So don't be afraid if you see the mediator calling for an individual session, and then putting you both in the joint session. The mediator knows what they're doing, and they know when it is constructive for the process to continue, if they bring you both, or where they need to meet each of you individually. Again, the outcome of the mediation is entirely in the hands of you, the participants. The outcome is fair to the outcome is considered fair to the participants of the mediation, not the mediator. The process is conducted fairly by the mediator. So you need to understand that the outcome, and you go through this entire process of mediation to create an outcome that is realistic and that can be fulfilled. It is lawful and enforceable. There are constraints to confidentiality, and that is when the mediator is aware of any unlawful activity, or it's regulated, or there are rules that affect the confidentiality in a mediation, and that is something the mediator will inform you about. So depending on the complexity of your issues and your mediator will give you more information on that. Another question we get asked as the mediator is, how long will this mediation take? Again, it depends on the complexity of the dispute and how frequently the participants meet. So mediation, you can decide how often, well, both of you decide, but all the participants decide in conjunction with the mediator how often we meet and how much of time we're going to spend on these issues. Remember, the time that is there is needed, and as Andre explained at the beginning, to explore your issues, to go underneath and your concerns and your fears and your interests, so that you both understand what is it that we want as a resolution in a mediation. Question we also get asked, how much does it cost you? It depends on your mediator. Your mediator will inform you of the fee structure, and you will know that at the outset. So your agreement to mediate should cover your fee structure. And what the rules and regulations and what we have currently in our law is that parties to the mediation or participants to the mediation can agree to share the fees equally, or one person can decide that they want to bear the costs. So you have that option as well. Now, I'm going to not address mediation and access to justice and litigation at this point. Just to give you my understanding of the advantages of mediation is that the more you use mediation in terms of your dispute resolution as a dispute resolution process, the more you understand the preservation of the relationship you're in with that person. So from the first time you attend a mediation session, and you will see this when you go into mediation, the mediator starts the work to achieving resolution immediately. There's no delays, there's no extension of time, there's no undue postponements. You move into the process from the moment you both start speaking to that mediator. Now, you can have legal representation. Nothing prohibits you from having legal representation. It needs to be constructive to the process, though. In civil and commercial disputes, the mediation that we use manages the relationship between the participants, if there's one to sustain. And what usually happens in these civil and commercial disputes is that they've got to understand the timelines and any delays that would be detrimental to their clients if they go to court. So in civil and commercial disputes, there also is a way of looking into the benefits of mediation that sustains the business relationship. I'm just going to again briefly talk about family mediation and divorce mediation before I hand over to Gunther on workplace and mediation and employee relationships. So with family mediation, now that's widely used, more especially when children are involved. Well, the Children's Act mandates the use of mediation, and that is something a lot of people don't know, especially when it comes to drafting their parenting plan or where there's disputes in the fulfillment of parental responsibilities and rights between unmarried parents. So there's a mandatory need for parents to attend mediation. What it does is it improves the communication between the parents so that they're not stuck in this adversarial, traumatizing relationship that in effect affects the children and their understanding of dispute resolution and peacemaking. So mediation in family disputes needs to be more emphasized to get co-parents to talk about how they foresee that relationship, because there's an ongoing relationship and they need to preserve that relationship and develop a communication strategy with each other. And you will also realize in mediation in family and divorce mediation that your negotiation skills are enhanced, and you also get to understand if we need to be flexible, how can we be flexible and how can we communicate to each other? So Gunther, I'm going to hand over to you. Thank you.
Viraj,
Thank you, Viraj.
Sorry, Gunther, before you continue, thank you very much for that, Viraj, quite insightful. I just have a couple of questions looking at the Q&A session on my screen here, and maybe you can answer a couple of questions quickly. And Andre, I have one or two for you as well. So first of all, the characteristics of a good mediator. I see a lot of attendees have asked the question, qualification, must you be an attorney? Will an HR practitioner be a good mediator? How do you respond to those questions?
Okay. So, Andre, if you don't mind, I'll take this one. The qualifications of a mediator, yes, there are qualifications out there that a mediator can obtain. And anyone can obtain the qualifications of a mediator. What makes a mediator a good mediator is that they're able to uphold the principles of mediation and uphold their ethics, the ethical standards of being impartial, of being neutral, of managing their biases and prejudices, of conducting a fair process, of ensuring that they're not advising and influencing the participants to reach an outcome, that the outcome is in the hands of those participants and ensures that those participants reach an outcome that is fair to them and in the eyes of the participants themselves, not the mediator. So those are the characteristics that they need to look out for in a mediator.
And Andre, a question for you. Will the Mediation Institute offer training courses later on?
Yes, the Mediation Institute will offer training. It's a minimum of 45 hours, so it will be a whole week. And we've also reached an agreement with an organization in the UK where our 5-day mediation course is a prerequisite for an international qualification. So once you've attended our 5-day training, it's a prerequisite, and then it's another 3-day course to be accredited as an international recognized mediator.
Thank you, Andre. So to those of you that are interested, you must just keep your eyes on the internet, on the newsletters and the web pages and social media. That will be announced in due course. And Viraj, before I hand over to Gunter, a key requirement for successful mediation. I see a lot of questions here. Can you force somebody to participate? Is it a requirement that both parties must be present? What do you comment? What's your comments on that?
All right. So you cannot force someone to mediate if they're not mandated to mediate. It's a voluntary process. So if they choose not to mediate, they must have valid and reasonable reasons as to why, if they do approach a court, as to why they do not want to mediate. And maybe they do have valid and exceptional reasons as to why they don't want to mediate. The other one is the being present in the mediation. It depends on where the mediator is in terms of the process. So if the mediator is doing joint sessions, then both of you need to be present. If the mediator is doing individual sessions and decides they're going to conduct the mediation where they meet one party on a specific day at a specific time, the other one doesn't need to be there or shouldn't be there because their individual session will be on a different day at a different time. So if the mediator calls for a joint session, the joint session can only take place if both the participants are in that joint session and present.
And a last question, somebody asked the question, why is it not made a legal requirement? So Andile asked the question, why can't it be mandatory in our law that all litigants on any matters must show the court that they have exhausted the mediation route prior to resorting to litigation?
We hope to get there. We see when people understand the benefits and the advantages of mediation, we don't want to, they must voluntarily use the process. Mandating it may create a habit, and there's a whole lot of research and articles on why mandatory mediation is a good way to start to create the habit of people using mediation as the first stop to dispute resolution or the beginning of dispute resolution. Currently, it's not mandated in South Africa. We were hoping that people voluntarily mandate themselves to go into mediation, but right now it isn't.
Great. Thank you very much, Viraj. And I'm going to hand over to Gunter. And Gunter, You're also an expert in labor matters, and a question that I see here, and maybe you can answer that a bit later on. What your thoughts on the differences between proper mediation as per the Mediation Institute versus conciliation at the Ccma and the dispute resolution centers? I'm handing over to you, Gunther. Thank you.
Thank you, Jan, and thank you, Virash and Andre. Again, good afternoon, beautiful people from sunny Cape Town. And yes, that's actually what I wanted to start off with. Immediately when you think, or when you hear mediation, in the labor context, you immediately think Commission for Conciliation, Mediation, and Arbitration. Now, I can safely and confidently say that in my career, I've attended no fewer than 500 conciliations. And not once have I encountered the implementation of mediation in the sense that we, the Mediation Institute, understand and do mediation. Now, that can be due to a host of reasons. Among others, perhaps the time restraint that commissioners have. And also, in practice, it takes at least, and say an average between 3 weeks and say 8 weeks to get a conciliation date. And that is either after you've referred a dispute for unfair labor practice or unfair dismissal. And during that time, emotions of either or both of the parties have festered to that extent where they come to the Ccma and not one of them is willing to budge from their position. And obviously that makes it extremely hard to mediate, other than the time restraints. And so, yes, mediation should start in the workplace rather than at the Commission for Conciliation, Mediation, and Arbitration. Now, is it implementable in the workplace? I'm of the firm view that it is. And what springs to mind is the grievance process that many employers have incorporated into their workplace policies. Many disputes between employees and supervisors and managers, even CEOs, partners, suppliers, it's rife in the workplace disputes. The benefits of mediation, Virash is fantastically articulated, and the benefits in the workplace can be, for example, where two senior managers are in a dispute. Both of them add incredible value to the company. The company does not see it fit to either conduct an incompatibility investigation in terms of the Labor Relations Act. Poor performance is not an issue, but the morale in the workplace has been negatively affected by this dispute between the two managers. And that also impacts on their productivity. Now, an employer, in fact, has an obligation to ensure a safe environment for its employees. And obviously that will translate into the productivity and success of the business. Mediation there would be the appropriate and ideal process to see if you can resolve the dispute between those two managers. And another simple example, and maybe a very sensitive issue, especially in our South African culture, is the case of sexual harassment. It's very rife, and it escalates extremely quickly to the labor court, unfair discrimination, where it could have been resolved at the workplace by virtue of mediation. See what the parties' issues are, give them the platform where they feel free and confident to state their case, knowing that they will be heard, that will not be used against them later on in litigation, and to see what the parties' interests are. The benefit there is, and perhaps what's extremely important, and this is where it also comes in, where it's the difference between the Ccma and mediation at the workplace level. If at workplace level, there is an ongoing relationship, at the Ccma, usually it's ex post facto. It's usually after dismissal or after the unfair labor practice has been referred. And like I've already mentioned, if emotions have festered. If it's implemented immediately at the workplace and timelessly, expeditiously, soon, there's no time for emotions to fester. There's a lot to be saved. Parties are brought to the table. Their interests are identified, among others, the ongoing relationship, the harmonious values and culture in the workplace to be maintained and preserved. And a dispute can be resolved so much better. The employees maintain their employment, the productivity is preserved, the values of the company is preserved. Where it also might be extremely relevant is when it comes to dismissals. Rather than conducting a disciplinary hearing, for example, poor performance in terms of the Labor Relations Act and the Code of Good Practice, Schedule 8, why not consider mediation? Avoid the risk of litigation, long, tedious, expensive process. Try to settle it through mediation where both parties reach an agreement, negotiated agreement that's beneficial to both. Avoid the risk of litigation. It's cost effective. Everybody happy-go-lucky. And also just one other important aspect, when it comes to the CCMA, the parties approach it with the attitude of, I was right, he or she was wrong. And Andre mentioned earlier, an important aspect of mediation is to separate the problem from the people. It's the same with the workplace. And it's very important that I define this line between a grievance process and a mediation process. When we approach in South Africa, and this is prevalent, when we approach the grievance process, it's also with the mentality of who's right and who was wrong. And the employee invariably wants a disciplinary sanction handed down on the colleague with whom he or she has the issue. Where it should be approached as not who was right and who was wrong, but what is wrong? What is the problem? And that can be determined only through mediation. Now, it's important, and this is a topic that can be spoken about for very long, so I'm going to try to cut it short. What employers, and this is what I'm going to advise as well, what I advise my clients, include a mediation clause as a structure in your grievance process, as a phase. Include it in your employee handbooks, include it in your workplace policies, to encourage employees to speak up, knowing that they will be heard, knowing that their interests are paramount. Their interests, not the persons are at issue, but the issue is at issue. The issue is the problem, not the person. And lastly, and I say this and I revert back to that every time about the CCMA. And I want to finish up with this. When it comes to the CCMA and mediation, in Afrikaans, there's a beautiful saying, die koel is deur die kerk. In English, they say that ship has sailed. So the prospects of restoring a continued relationship between the parties have slimmed down substantially at that stage, where it could have been resolved amicably at the workplace. Thank you, Jan.
Thank you very much for that, Gunther. I'm just going to have a quick look at some of the questions that came in. And if you allow me just an opportunity to have a quick look here before I hand over to Renee Bosov, our next speaker. I've highlighted so many questions came in. What are your options if you feel the mediator is not impartial or upholding mediation principles? Can you request a different mediator? How do you respond to that, Gunther?
Thank you, Jan. It's a very good question, and yes, it is entirely your right to ask, in fact, to raise the issue. Tell the mediator, I'm not comfortable. Remember, the process is voluntary. You can get up and walk out at any stage. If you're uncomfortable with the process, especially as to how the mediator conducts the process, you are entitled to raise the issue and tell the mediator, look, I'm not comfortable with the way this is being conducted. I would like another mediator. It's entirely your right to do that.
Thank you very much for that. And then Gunther, who pays for mediation?
That is between the parties, yeah. The parties can agree to either contribute, go 50-50 split. One party can offer to carry the costs. In the labor context, it would usually be the employer who carries the cost. Civil and commercial, the parties can agree and negotiate on who contributes or who carries the cost.
Thank you very much, Gunther. Thank you for your participation. And ladies and gentlemen, our next speaker is Mr. Renee Bosov. Renee, before I hand over to you, I see a lot of questions or comments pertaining to Section 41, and you will know exactly what I'm referring to, came in. Maybe if you can comment on that. And I just need to quickly answer a couple of questions here. First of all, should minutes of the meeting be taken on Z Visser on Z? Well, preferably not. Remember, it's a confidential process. Confidentiality is of utmost importance, and as a mediator, you will basically repeat that a couple of hundred times during a proper mediation. So taking minutes per se is really not ideal because it's an off-the-record process. However, the mediator may, of course, take notes in order to better understand the positions of the parties and the outcome required. And then somebody asked the question, what about the CCMA, the commissioner that asks you to step outside the room and we'll have a discussion with other individuals? Well, there's nothing with the other party. There's nothing wrong with that. That is an attempt to get the parties to reach an agreement. And then a couple of others as well pertaining to training. Ladies and gentlemen, please subscribe to our newsletters, have a look on our website. We will most definitely answer all those questions in due course pertaining to where, how long, etc. So at this point in time, nothing is cast in stone at this stage. It's in the making, so in due course it will definitely be announced. Renee, over to you. Welcome.
Thank you, Jan. My name is Renee Bosov. I'm a regional magistrate with more than 27 years experience in the adjudication of legal disputes. What lessons have I learned with regard to litigation over these years? Let us consider my first rule of thumb. It might sound a bit controversial, but it is even a bad settlement is better than a good court case. Now, there are good settlements out there and there are good court cases. The statement is just to provide some perspective and to make us think. Let me explain some realities of litigation. Even if you win a court case, you are not necessarily guaranteed of your money back. There are different types of cost orders out there, and often we throw good money after bad money, resulting in us not getting a cent back, for instance. The law is often very technical, subjective, and to an extent speculative. Even the same set of facts can give rise to different opinions among jurists. The rules of civil procedure is often, it's very rigid and cumbersome, making it a minefield in some ways. Litigation is very expensive and often comes with long delays and backlogs. Not even a win. You win your case, doesn't realize or make you, it's not final, as there can be several appeals and even reviews. The parties to a dispute suffer a definite lack of control over the case and the dispute resolution process, as there are normally attorneys involved who may not share the same sentiments. Sometimes I have encountered it in the past. People are satisfied with a simple apology. They're not necessarily interested in a long court case. the court process sometimes is limited in that the legal remedies often only produce a win-lose scenario. It does not, as Andre and other speakers have rightfully said, encourage or make room for a win-win approach. Let me just give you a few examples of what I encountered, and it's just a few. Mrs. D worked for a surgeon. He always charged her contracted in fees for similar procedures in the past. It was part of her fringe benefits. She went in for another operation, and on her return to work, she and the surgeon's wife had a huge fallout that led to her constructive dismissal. Suddenly, the surgeon claimed a contracted out fee, a medical aid by debit, and a balance of 2,500 rands was demanded from Mrs. D. Now, Mrs. D and her family considered this a matter of principle, and despite my advice, vehemently denied the claim, instructed an attorney, and the court case followed. During the proceedings before the start of trial, I advised him, your documents are a bit defective, and the husband asked me, how difficult can it be? Now, they lost this case, of course, because of a technicality. They were prevented from discussing or from arguing the case on its merits. The result was a resounding loss. The 2,500 rands became 51,000 rands. Now, that is a very expensive error in any man's language. The second example is where a lady took in jewelry to a bank for safekeeping. The bank put the jewelry in a normal safety deposit box, not even a safe, where it was later stolen by thieves using normal angle grinders. The lady sued the bank for the 7 million rands and for compensation. She won her first 2 cases in the High Court, who dismissed ABSA, the bank's claim that they owed her only a normal duty of care. The bank then took this case on appeal all the way up to the appellate division as court of last instance, where they eventually won. The court ruled that the bank is not responsible to compensate the lady and that they only had an ordinary duty of care. Now, the third example is a classic story in quite a few ways. 3 friends went hunting in the old days area. The second evening, after some liquid refreshments, 2 of the hunters found an escort agency, as it was known then, in Pretoria, and ordered 3 escorts on an urgent basis. They paid with a friend's credit card without the friend knowing. They even flew in the escorts to the hunting lodge, also on this bloke's credit card, where all 3 gentlemen enjoyed the company of these ladies. Now, the wife of the financier eventually discovered this loss via his credit card statement and instructed him to get the money back from his friends. He complied, he went to see an attorney, and litigation followed. On the morning of the trial, I told the parties that a local newspaper, the Soutpansberger, inquired about this case. Suddenly, there was an extreme urgency to settle. Now, do you think the lawyers actively encouraged a settlement in this case? Was litigation the right option in these cases? Except for the second example, I would say definitely no. Banks and insurance companies are powerful financial institutions with a lot of money behind them, and often they litigate out of a position of strength. That was illustrated by them proceeding all the way to the appellate division, where they eventually won. Now, this case also illustrates to us that even so-called sitters or obvious cases can go haywire. What does safekeeping imply to you? There is, whether we as legal minds like it or not, a bit of tatama chance, tatama millions involved in litigation. Mediation is the fast-growing international phenomenon and is a form of alternative dispute resolution. You will undoubtedly hear a lot more of this concept in the future. There are also undoubtedly lawyers present here today. And I can say to you unequivocally, there will always be cases where litigation is the best option. But my advice to you is to embrace mediation. We have received some questions about Rule 41A. Rule 41A of the High Court rules now introduces mediation as a compulsory pre-litigation step. It came into effect 9 March this year. Essentially, the rule requires that before a party seeks to embark on any action or any application in any high court, the party must deliver a notice to their opponent, affording them an opportunity to agree to referral of the matter to mediation or to at least seriously consider mediation. It remains to be seen how this rule will be applied in practice. But the reality is mediation is on us. My prediction is that it is not going to take long for a punitive cost order to be made against a party who did not or does not regard mediation seriously enough. Most new laws, almost all of the newly enacted laws of the legislation of the last 10 years makes provision for alternative dispute resolution like mediation and or arbitration. This is also reflected in the modern day law of contract, as most modern day contracts contain similar provisions. The stark reality is that litigation has become unaffordable for most, and it does not promote creative solution seeking. We live in a global world where global solutions are needed. With mediation, different time zones and legal systems are no longer a barrier. Internationally, courts can be approached to make mediation agreements, orders of court, to make it legally enforceable or legally binding. People tend to be much more informed nowadays and like the idea of self-determination or the use of a mediator to assist them in reaching a solution or settlement for themselves. It is imperative for us not to stay behind and to rather use our legal knowledge and or communication skills as tools to become involved, whether it be as mediators, facilitators, lawyers, or industry experts. Hopefully, more matters can be resolved outside of court without engaging in frivolous litigation, just to settle anyway 2 years later and many rands later at the steps of court on the day of trial. The Mediation Institute of South Africa has my full-hearted support. Thank you.
Thank you very much for that very informative presentation, Renee. ladies and gentlemen. And Renee, before you go, are you still there? Hello, Renee. Right, so I think there we
Yes.
go, Renee. I've got a question that I think you will enjoy, and the question is: when is mediation in criminal matters an option?
I am currently a regional magistrate in Alexandra or the Wynberg region, where I deal with all the serious cases in that whole region, including Midrand, Sandton, etc. And I can just say, from our perspective, we got 2 full-time mediators present at the criminal court, and it's often referred to as restorative chapters.
Great. Thank you very much for that answer. Thank you, Renee, for also explaining to us Rule 41A. Thank you very much for your participation. Ladies and gentlemen, Andre, Viraj, Gunther, thank you very much for your participation today. I see that we've received a lot of questions. Unfortunately, time-wise, it's not possible to answer all those questions. I'm going to ask the participants, in other words, the presenters, to maybe just try to answer some of those questions after we have ended this session. And those of you that have posted questions, you are welcome to remain online and to see if it's possible for any of the presenters to answer your questions. As stated earlier on, training will follow in due course. Port Elizabeth, Cape Town, wherever you are, most probably, Andre, it will be online. Is that correct? Yep, I see Andre is indicating yes. So wherever you are, you can attend the training. And as Andre explained earlier on, it will be accredited internationally. And of course, your prerequisite in terms of prior learning, qualifications, that will all be addressed as soon as we launch the program. Andre, anything further that you wish to say about that? Great. Sorry, your microphone was muted there, but I see that
you've explained well. Thank you so much, Jan. I appreciate it.
Great. Thank you very much, ladies and gentlemen, for participating, for attending. As I said, register for our newsletters and have a look at the website. And we will now end this presentation. However, I will keep it open for the sake of the presenters to maybe answer a couple of questions. I've typed in a couple of answers already, but I see that there are about 86 open questions. Thank you very much. Right, presenters, you can switch your video feeds off and microphones as well. Thank you.
Thank you. We are just going to, before you end, Jan, we are going to answer a few of these questions as well. Thank you so much.
Okay, are you going to do them live or are you going to do them on a Q&A?
I don't mind taking one of them. I see one of them's been asked about what happens if I don't reach resolution in mediation. I don't mind doing it right now.
Yeah,
yes,
go for
please,
it,
if you don't mind.
Okay. So in mediation, you would have heard, so far you would have heard that people, it's voluntary, and you have Rule 41A that says you need to seriously consider mediation. So that is an invitation, firstly, for lawyers to serve that notice to mediate and to get their parties to mediate. It doesn't always mean that the invitation to mediate or this notice to mediate will be accepted. So it doesn't, you've got to show again reasons why we didn't reach resolution in mediation. Now, even if you don't reach resolution in mediation, what does that mean for you? It means that you now, at least if you've attended mediation, have a clearer understanding of the issues in dispute. So if you even sat in one mediation session, or you've sat in a session, a few sessions of it, but you didn't reach resolution, you would have at least gained some perspective on what the other participant sees as the problem in reaching resolution. You'd have had an opportunity to look closely at your case, your own case, or your own issues in dispute, and be able to weigh up options, or maybe you have a better option instead of sitting in mediation to rather go to court. And so you would be able to understand that the resolution I reach in mediation is not the best resolution for me. I can reach a better resolution outside of mediation. You can also see that if one of the participants don't act in good faith, you can enter the mediation, as Gunther and Jan have spoken about that. So not reaching resolution in mediation is not the end of the world. You still have access to other forms of justice, other forums, and it's not because you didn't try hard enough, but because there were exceptional circumstances or other circumstances that did not lead to the resolution in mediation. And of course, the lawyers, you have your, well, I would say, obligation or your duty to inform your clients about mediation. So there is a space for lawyers in terms of Rule 41 and in terms of whether resolution is reached in mediation or not. Thanks, Jan.
Thank you very much, Viraj. Will you and Andre and Gunther, will you still answer questions on the Q&A after the session?
Yes, I think we can take another 3 or 4 questions, which is quite important. Thank you, Jan. We really appreciate.
Great, thank you very much.
Yeah.
There we go. So all the questions, you should see them on your Q&A. You are free to pick and to answer.
Okay, so I've got a question here with regards to costs. Costs are a factor, we know that. What incentive is there for a mediator, for the mediator to have to draw matter to an acceptable end within a reasonable time frame? So as Viraj said, the mediators has no interest in the outcome of mediation. And costs will be a factor, yes, but you will be informed exactly about there are no hidden costs in mediation. So you will know exactly. And then I just want to emphasize, the mediator has no interest in the outcome of mediation.
Gunther, is there a question?
Yeah, sorry, Rash, I'm running through the questions quickly. And I say one is, am I suggesting mediation as an alternative to disciplinary hearings process and incapacity processes? I'm saying, yes, it is a consideration to definitely keep in mind, due to the risk involved in following the processes as per the Labor Relations Act. Remember, if an employee is found guilty in a disciplinary process and he or she is ultimately dismissed, there is a dispute for unfair dismissal to the Ccma. That is possible. Same with poor performance, same with any incapacity inquiries, whether it be general incapacity or ill health incapacity inquiries. Where it is a mediatable issue, I say go for mediation. Disciplinary hearings, that will be determined on a case-by-case basis. For example, I did mention the rather complex issue where 2 managers are at loggerheads and none of them particularly commit any misconduct. So the company might have to consider the incapacity process if it indeed impacts on the operational requirements and productivity of the employees in the company. So yes, mediation might be a process to consider there. Mediation is always and can always be an alternative to any of the processes, I feel, in the Labor Relations Act. Remember, it is voluntary, it is confidential, it is without prejudice. So it is non-binding up until that point that an agreement is reached by the parties. So it can't be held against them. If all else fails and the mediation does not result in an agreement, the processes as per the Labor Relations Act are still available to the employer as well as the employee. So there's nothing to lose by first trying the mediation, but there is everything to gain. So that is my answer to that question. I see there's a range of questions for me, which I appreciate and which I will definitely take time to answer after we've concluded this. And you can also direct any questions to the Mediation Institute. The emails are there. and I will gladly answer them as well.
Okay.
Thank you very much.
All right. I'm looking at a question, Fizike's question. Can an HR manager be the mediator within a company? Gunther, do you have any thoughts on that before I go into my usual impartiality speech?
Thank you very much. I was going to start with that. Yes, it's extremely important that the mediator be impartial. And it must be remembered that the HR representative is also going to have an ongoing relationship with those employees. An external mediator, for example, has no ongoing relationship. It's got an objective view as to what's going on. And what's important is the preserving that relationship, that working relationship between the parties. If the parties, the employees are comfortable with the human resources practitioner facilitating the mediation, and the HR practitioner feels that he or she will be able to conduct themselves impartially, that they have no vested interest in the outcome, then I don't foresee a problem. I don't foresee a problem, but it's advisable that due to the continued relationship, there might be a blurred line between a vested interest in the outcome. So I would advise to rather consider an external, impartial, and qualified mediator.
Great. And also, just to add to that, Fizike, is that confidentiality is key. So if you suspect that information shared within the information will be shared within the workplace, and that it impacts the confidentiality of the process, yeah, again, as Gunther said, rather seek to get an impartial outside third party. Any other questions that you believe we can?
Viraj, if you don't mind, I've got 2 questions for you. It's basically based on the same principle. Is mediation final and binding, or do we sign agreements at the end? And then from a few others. So if mediator does not make any final decisions as to how to go forward, what if both parties are unwilling to agree to a way forward? Then do we have to go to the next level? So it's basically 2 questions, my apologies.
Okay, so the mediator does not make a final binding decision, if I understand correctly. And the decisions come from the parties, and I think we need to really stress that. The decisions come from the parties. The mediator doesn't make any final binding decision. The parties reach an agreement, they can take that agreement and have that agreement made into a court order, or act on that agreement. The second part is, yes, if you've exhausted mediation, if you've exhausted processes of mediation, there's no agreement reached, you can then move into the next process of litigation, arbitration, or any other dispute resolution forum.
Thank you so much.
Okay. I think we've got most of them.
Yes. So thank you so much for your time. Viraj, do you have anything else to add? Gunther? Okay, so I think we are going to end the session.
Thank you, Andre. If I may,
please.
through sexual harassment in there deliberately, and I see it was picked up and there is a question. And the question is, it is an extremely serious offense. So would mediation be appropriate? And indeed, yes, it is. It's an extremely serious offense, absolutely. But what is the purpose of mediation? Is to determine the interests of the parties involved. Remember, it's a voluntary process. It's up to the complainant to consider and to agree to mediation or not. And in that process, the complainant, as much as the other party, has to agree to the outcome. At any time, he or she can walk away. And also, in sexual harassment cases, it takes an extremely heavy toll on the complainant, emotionally, physically, psychologically. The alternative, litigation, a worn-out process, takes extremely long to finalize. It is expensive. That adds to the emotional, physical, psychological toll on the complainant. Whereas mediation is an expedited process, again, without prejudice, the parties' interests are protected, and it's voluntary. At any stage or time, the complainant can decide to walk away. Having said that, there are cases where, and this is not making light of the fact, however, it's an extremely serious issue, especially in our country. But I have come across, in fact, I've dealt with cases where remarks were made that were construed as being in a sexual nature and they were unwelcome. The parties, the complainant was sat down and asked if she would be willing to mediate this process with the other party. And it was determined, actually established, that the other party meant it in jest. The complainant didn't accept it that way, and it was identified, determined, and it was resolved amicably, and the issue was resolved. Now, not all cases can be resolved through mediation, especially when it concerns serious offenses like sexual harassment. And I'm not saying it will be, but it is definitely a consideration, keeping in mind it's voluntary. That is my answer to that question. Thank you, Andre.
You're muted.
Thank you so much. The last answer that I would like to answer from my side is, can we get the presentation? Yes, the presentation will be made available. It's an automatic procedure. 24 hours from now, you will get a link to the recording of the presentation. Viraj, anything you would like to add, Gunther?
Well, from my side, I didn't get to say goodbye to all the other participants before they left at 1 o'clock, but those that have remained, thank you so much for staying with us and listening. Again, this is a brief discussion. We will go into each aspect in future sessions, more detailed. I see a lot of questions coming up about Rule 41A, which we didn't cover because we want to leave that for a whole separate session. So thank you very much for staying with us throughout this presentation. Thank you, Andre. Thank you, Gunther.
Yeah, just to
From
add
my
on
side,
that.
thank you, Andre. Thank you, Viraj, and thank you everyone for joining.
Yeah, from my side as well, I see there's still 260 people online. Thank you so much. We really, really appreciate everything. And if you have any questions, please just send us an email to info@mediate.co.za. Thank you so much and enjoy the rest of your day.